The Zoning Board of Appeals is the permit-granting authority for projects that do not meet the requirements of the city's zoning bylaws. The board's function is to approve or deny requests for variances and special permits. They issue findings through the public hearing process. Appointed by the mayor, the Zoning Board of Appeals is made up of 3 full board members and 4 associate members. The following Zoning Board of Appeals meetings coverage is brought to you by the Government Channel, a service of the City of Framingham.
It is 7 p.m. This is the City of Framingham Zoning Board of Appeals. Today is March 11th, 2026. In a minute, we'll go through and start the agenda. I just want to remind everybody that this meeting is being held as a hybrid meeting, which means there's people here in attendance in person. We also have Zoom attendance, fairly robust group who has joined us virtually. Didn't want to make the trip out this evening, but we will be conducting this meeting so that anyone who wishes to participate either through Zoom or in the room has the ability to do so. I would ask that that you wait until you're called upon before you attempt to speak. And that if you are going to speak and you're in the room, please come to one of the mics, make sure the mic is turned on. The mic at the podium is usually always on. The mics on at the tables, which you're perfectly welcome to use and sit down. If you'd like, you'll have to press the button where it says push, and so that the light turns green. Introduce yourself and your address if you're a Framingham resident. If not, your connection to the application. And I will try to, we'll see how it goes tonight. Those of you who were here last time for the longer hearing know that we have to try and keep things moving along, otherwise we'll be here all night. We do have a number of matters on the agenda. The first 2 of which, after we talk about the minutes, are requests for continuances. And then we'll have the 945 Concord Street matter before we get to the Salem End Road matter. And then we have a couple of new hearings after the Salem End Road, after we're done with that for tonight. So with that, we'll start with the first agenda item, which is the acceptance of the minutes from February 11th, 2026. Is there a motion to accept those minutes as prepared?
I will make a motion to accept the minutes as presented.
Okay.
I'll second that motion.
Motion and a second. All in favor?
Aye.
Aye. And I would say, excuse me, I would say that everybody is in person on the board tonight except Christina Johnson. And Christina has joined us from her vacation. I don't believe her background is real, but I do believe she is in a location that might have a background like that. Is that accurate, Christina?
Yes, that is a picture I took the other day from the British Virgin Islands.
But thank you for joining us and taking time out of your vacation to assist us and the inhabitants of the city of Framingham with our agenda tonight. So the first matter on the agenda that has been continued from last time is 733 Waverly Street. I understand Mr. Galvani is going to be joining us by Zoom. He's got his hand raised to request another continuance on that. So Paul, why don't you go ahead?
Okay, can you hear me?
Yes.
Okay. Good evening. For the record, Paul Galvani, attorney for the applicant, 733 Waverly LLC, which is owned by Bill and Walter Villa. We, as per my correspondence, we are requesting a continuance to April 8. We've made, there have been discussions with the owner of 729 Waverly Street. And this parcel is abutted on 3 sides by 733 Waverly Street. So we have an accepted offer to purchase, and we're moving forward. Mr. Viller has now engaged his architect to begin the process of combining this parcel. So we're making some revisions to the site plan to incorporate 729 Waverly. 729 Waverly contains an area of about 8,000 square feet. So that's going to be incorporated into the project, and really will make for a better project. And again, we're doing some, I think, already started on the redesign. So we should have a revised plan prior to the next meeting.
Okay. And you've signed an extension of the decision deadline. What's the extension date?
May 31st.
May 31st. Okay, thank you. Okay, so that's good progress. I think that's great. Is there anybody have any questions on the continuance request? Anybody out there in the audience? Is there a motion to continue this to April 8th at 7 PM?
I will make a motion to continue it to April 8th.
Is there a second?
Second?
Who's on this case?
No, who's on, I think
it's Christina.
it's Christina. Christina has to do it.
Christina, I think you're on.
Yes.
Yep. So there's a motion to continue to April 8th. Is there a second?
I'll second that.
Okay, motion is second. Any further discussion? Hearing none. All in favor? Aye. Christina?
Yes.
Thank you. Okay.
Right, thank you very much.
Mr. Galvin, see you next month. All right, the next is 837, case number 2601, 837 Concord Street. That one was continued from last meeting. I think that the applicant wasn't here last time. I understand that the applicant is working with the building department or the economic development department, and that it was suggested that at this time a continuance is appropriate. So they are requesting also a continuance to April 8th. I assume that it's. That is Meltzer, Johnson, Yan again. So is there a motion or any discussion?
No discussion.
No
I'll make a motion to continue it.
Okay, motion to continue to April 8th. Is there a second, Christina?
Second.
Okay, motion and a second. Any further discussion? Seeing none. All those in favor? Aye.
Yes.
Flat?
Aye.
Thank you. Okay, so that is April 8th. Okay, next. It's 945 Concord Street. Ruth Lacrosse, case number 2528. That was continued from last month. We do have an interpreter again, I guess a different interpreter from last month. And that is Cynthia Rue. Do we see Cynthia? Is she on Zoom somewhere?
She's raised her hand. She's right there.
Okay, so, okay. All right, Cynthia, you're all set. You can hear us?
Yes, I can hear you well. This is
Okay.
Cynthia Rose.
She's there. She's the applicant's there, too.
Yep, okay, so, yeah, if the applicant could come forward. And so,
Good afternoon.
good afternoon, so just give me 1 second. So last time we continued this, we had some discussion. We did hear from the building commissioner, and there was discussion of the fact that we had the ability only to do something if there was a request for a use variance, which it was advertised for a variance, and there's been an additional clarification of a request for a use variance. And I don't know if there's any update. I wonder, Cynthia, if you could perhaps interpret what I said.
Yes. Señora Ruth, le comentan que la última vez que hablaron con usted había una discusión acerca del edificio y el comisionado estaba viendo la habilidad de usar ciertas variantes, ya que se había promocionado el lugar con ciertas variantes. Entonces quieren saber si hay alguna clarificación de parte de usted en cuanto a alguna modificación que se haya realizado.
Nadie no me ha dicho nada sobre eso. Pero primero, antes de empezar, por favor, necesito hablar de otra cosa, por favor, si me permiten solamente 3 minutos.
Nobody mentioned that, but I wonder if before we start, I can have 3 minutes just to comment on something.
Of course,
It's very important.
of course.
Okay.
Go right ahead.
Then I'm going to talk with us about my God. They are from John 10.
She meant John 10.
John 10.
Sorry, my name is Andy Leocal Alonso, and I'm her oldest son. Last time I was here, but I was in the back with the baby because I didn't want to.
Este rápido. Juan 10:27. Corre. ¿No lo tenés? Ok, 10. Dije que lo buscara. Ok, 27. 27. Ok, 27. Ok. 27, 28, 29, 30.
So on John 10, 17, 27, it says, "My sheep hear my voice, and I know them. They follow me. And I give unto them eternal life, and they shall never perish, neither shall any man pluck them out of my hand. My Father which gave them me is greater than all, and no man is able to pluck them out of my Father's hand."
Okay, is that okay? I want to tell us that if somebody here feel this heart about God, we have to listen, because Jesus coming back again. Today we hear, tomorrow we don't know. We have dos caminos.
She's trying to say that we have two paths.
Uno para la vida eterna,
One for eternal life,
el otro es para la muerte eterna.
and the other one's for the eternal death.
Muchas personas dicen que Dios no existe,
A lot of people say that God doesn't exist,
pero es verdad, Él existe.
but it's true, God does exist.
Muchas de esas personas son los primeros cuando están enfermos que buscan ayuda de Dios.
Those same people are the first one to seek God's help when they are sick.
Me gustaría hablar mucho de eso, pero yo no sé hablar.
I would like to talk more about that, but I don't really talk more English.
Pero Dios les va a tocar el corazón para que entienda que esta palabra de verdad necesitan de Él para su salvación.
But God will touch your heart to know that you need a lot of this word.
Yo no les voy a quitar mucho tiempo.
I will not take a lot of time.
Jesus coming back again. Be safe.
Okay. Is there,
Thank you so much.
yeah, so we're not probably qualified nor endowed with the task of deciding whether God exists or not. But is there anything with regard to your application that you want to say before we?
Creo que no estamos calificados para nosotros decir o hablar acerca de la existencia de Dios o de esos temas, pero quiero saber si usted tiene algo que exponer con relación a lo que estamos hablando del edificio.
Todo lo que yo tenía que decir de mi parte, yo lo dije la otra vez. Ellos son la ley. No puedo decir nada, simplemente ellos son la ley. Ellos harán lo que Dios le ponga en su corazón. Y esta noche no le hablo de Dios, no les hablo de Dios por mi aplicación. Le hablo de Dios porque es mi trabajo para Dios. Hablar de Él donde quiera que yo llegue.
I don't have anything new to say from the last meeting, but I'm here and I understand that you are the authorities and you are going to decide. I just hope that God help you guide that answer or that resolution. And I'm not here talking about God because of this matter. But it's mostly because that's my job for God.
Okay, so let me get a little bit specific. I have a couple of questions. If we were to grant a use variance, we'd probably have some conditions for any operation of the trailer at 945 Concord Street. What are the hours that you wanted to operate the trailer at the location?
Si le vamos a nosotros otorgar el uso de unas variantes en cuanto a su negocio, tenemos ciertas condiciones de operación. Entonces, en cuanto al tráiler que usted quiere poner en la 195 de la Concord, ¿a qué horarios piensa usted trabajar ese negocio?
Yo hablo de 8, antes yo abría a las 7, ya no porque yo tengo, por causa de mi hijo, ahora yo pienso empezar a 7, hasta las 10 de la noche.
De 7 de la tarde a 10 de la noche.
No, de 7 de la mañana hasta las 10 de la noche.
I was working different hours before, but now because of my family or my son, matters, I'm thinking about working from 7 to 10, 7 a.m. to 10 p.m.
Monday, 7 days a week, or what days of the week?
Monday
¿Qué
to
días de la
Saturday.
semana?
Monday to Saturday.
Okay. All right, so that was my question. Does anybody else on the board have any questions or concerns?
Just, I know that last month's meeting, there was some concern about noise. Huh? The music, yeah. And I don't know if she preaches or not during, but, that was a big concern, and that's really the only thing that sticks out in my mind was it being a noise violations or something that disturbs the neighborhood, because I would, if we do grant this, I would like some restrictions on the noise, on the music, and any loudspeakers that she may have.
En la última reunión nosotros hablábamos acerca de el ruido o de la música que usted tiene en su espacio. No sé si necesariamente usted está evangelizando o simplemente tenga música con alto volumen, pero nuestra preocupación sería en cuanto a causar ciertos disturbios en el vecindario por estos ruidos excesivos y creo que pudiéramos solicitarle que tenga ciertas restricciones en ese aspecto.
Bueno, es una bocinita que yo tenía pequeñita solamente para mí. Las personas que venían a comprar podían escucharlo, no es persona de lejos. Pero si dicen que no, yo lo quito. No tengo ningún problema.
I also had a very tiny speaker there that just the people that was purchasing in my business could hear. It was very minimal noise. But if you tell me that I cannot have that little speaker for music in my business, I don't have any issues with that. I can just not turn it on.
Okay. Anybody else have any questions, concerns?
About the matter of hauling it off, bring it in, and then taking it away at the end of the day.
So is that a question, whether she'd be
Yeah.
leaving it there overnight or
Exactly.
whether taking it home? Okay, so is your plan to leave the trailer overnight, or do you bring it to a different location after you close?
Todos los días, I understand.
Sí.
Todos los días yo voy llevándolo, pero si ustedes me dan permiso para dejarlo, me sentiría muchísimo mejor.
I've been just driving it back and forth every day, but if I have a permission to leave it in place, that will be very well appreciated.
Do you have permission from the landlord to leave it in place?
¿Usted tiene permiso del arrendador para dejarlo en ese lugar?
Mi único problema con ellos era de variation.
The only issue with them was the variations.
I'm not quite, I understand, I don't know what that means.
¿A qué se refiere con eso?
Que yo estaba, solamente el problema que ellos tenían es el problema del
The variance is what she means.
Oh, depending on, I mean, my personal feeling, I'm
Let's just
sorry.
pero con otras cosas no tiene ningún problema conmigo.
The only issue we had that was about that variant, but I don't think they had any other issues with me.
Okay.
I mean, my personal feeling is that she should cart away just like any other food truck. Food trucks park, go back to where they park their food truck and restock and refuel, put more propane in there, whatever they need to do. And I think what she's basically asking is that she wants to operate this almost as a food truck. And what Commissioner Bray's objection to it was, this is a trailer. It's not a food truck. So therefore, if we do grant this variance, I think she should operate this like a food truck.
Drive it away when she's done.
Drive away when she's done.
Yeah.
La situación es que en algún momento usted le querían dar permiso como si este fuera un negocio de un camión de comida, pero en el caso de su vehículo es un tráiler, no un camión de comida. Creo que si le damos el permiso para tener esto en ese lugar como un camión de comida, entonces usted tendría que manejarlo de regreso y de ida todos los días.
No tengo problema, les dije. Yo he estado haciendo desde que empecé. No tengo problema.
I don't have any issues with that. I've been doing that since I started.
Yeah. And I think that takes care of, maintenance will be done somewhere else.
If she operates as a food truck, doesn't she need a different kind of a permit from the health department, all that kind of good stuff?
Yes, she press her.
So if I have this correct, if you operate as a food truck, you would need a different type of permit.
But she has a
She
health.
has a food truck permit.
She has a food truck
The
permit.
problem is the problem is Mr. Inspector
This is
Bray,
zoning.
Commissioner Bray, is gave her a violation based on the fact that she's operating a trailer, not a food truck.
She has a.
She has a food
Board of
truck
Health.
permit,
Okay.
Health Department food,
So she has all the correct licenses.
to operate
So
a
how do
food
you
truck.
convert,
That's not our
Okay.
issue.
No, yeah.
Yeah, that's if the health department is okay with that operation from a health department licensing standpoint, then that's the health department's call.
okay, so if she's licensed correctly as a food truck,
As a food truck.
then we consider it as a food truck and move on from there.
Well,
That is what.
Sort of.
My recommendation
Sort
is,
of.
yes.
if we grant the variance.
Christina, any thoughts?
I agree. I think that we're granting a use variance so this can operate like a food truck and it should be towed off the premise, every evening after closing.
And what do you think about the hours? What does anybody think about the hours?
I think the hours are sufficient, but I do share Mr. Yan's concerns about, loudspeakers with noise emanating off of the property.
Okay.
But I am fine with granting the use variance with the appropriate conditions.
Okay, let me go out to the public and see if anybody has any comments or questions for the applicant. Anybody here in the room? No?
We'll wait for the
I
big
have,
show.
no, I do have somebody in Zoom, Marianne Tratchell. Go ahead.
Hi.
Hi.
Hi, Marianne Tratchell. I'm 20 Nipmuc Road, in Framingham. I was just looking on Google Maps, and this, it looks like where she's parking her truck is just right across from some residences. So I was just wanting to comment that if she's operating, I believe what you said, 10 o'clock at night, I guess if she's keeping her music down, I was just thinking about the people living on that street, that's
Yeah,
all.
yeah, so Concord Street and that building, and maybe we should talk about where she has her truck, because if she's back behind the building, then there's really no exposure to those residences across the street. Cynthia, maybe you can give her a clue to what we're talking about.
Ellos están hablando de las limitantes del terreno donde tiene usted su tráiler de comida. Y usted está en la calle Concord Street, ¿verdad? Y al cruzar están residencias. ¿Cuál es más o menos la proximidad?
Yo estoy al otro lado. Las residencias están donde viven. Hay dos casas. Yo creo que son negocios. Yo no hago bulla de verdad. Yo le voy a enseñar al señor, dígale por favor que le voy a enseñar lo que yo hacía música para que ellos por lo menos tengan una idea de la música que le están hablando, por favor.
There's some homes that I think are businesses, not residences, but even if they are residences, I don't play any loud music or high volume music. And I have my phone here with, and I can show you like what is the type of speaker I use when I'm working.
No, please,
No
no.
es necesario.
No.
So,
It's like that's it.
Yeah, it's fine. I think we're coming to the conclusion that you should just eliminate the speakers.
but yeah, we'll get there. Is there a specific spot on the lot where you're allowed to park by the landlord?
¿Hay alguna parte del terreno donde usted pueda estacionarse que le haya indicado su arrendador?
Sí, ahí mismo que estoy.
Yes, I'm in the spot that he designated me.
Okay, can you describe what that spot is?
¿Me pudiera describir cómo es ese espacio?
Antes yo estaba adelante en una esquinita, solo que no iba a parquear más carros cerca de mí, y él me dijo que me moviera más para allá, en la esquina para allá, ahí estoy.
Es como en la esquina derecha.
Yo estaba en la izquierda, en esa esquina de arriba, ahora yo estoy como en la esquina del building para atrás, allá.
So I used to be in the left of the low.
Yeah,
And now
let's
the-
short circuit this. Hold on. I'm sorry, Cynthia. We're going to try and make this easier. Do you see the spot on the screen where you're allowed to park?
Usted puede ubicar en esta
En esa
imagen dónde es que se puede
You
usted
can walk up to
estacionar.
it.
Oh,
No, en el mapa. Sí. Ese es el building. Ese es el building. Sí,
That's only showing the parking in the front.
sí.
There's parking in back of the building, Jackie, isn't there?
No, it's just,
Can you help your mom?
Yes.
Go up there, please. I think she has a little difficult reading maps.
This one will be the entrance of, for the vehicles to come in. So she used to be over here in this parking lot, but after the landlord told her to move over here, she's here.
So it's
Here.
right on Concord Street,
Yes.
on the edge of Concord Street.
Yes.
Okay,
So the vehicles have more space where to park and not be bothered.
okay. So it looks like,
Yeah.
to make a comment, it just looks like it's away from some of the residential areas.
Oh, but there's residents across
There's
the
residents
street.
across the street, yeah.
It's mixed.
It is mixed.
Yeah, it seems like what she said is correct. On the southern portion where she was parking, there's two businesses. There's a Right Track Painting in front of it and a hair and gray salon, and then residential houses until the corner
I mean,
of Old Connecticut.
No hay casa de residentes.
She's been at the edge of the parking lot, right, kind of abutting the church. It's right next door.
Correct. Yeah,
Right, okay.
I've seen her there before, yeah.
So the landlord now wants you not next to the church,
No,
but
no.
in the middle of the parking lot now?
Oh, sorry, that was before.
O sea,
Oh, sorry.
So which
Go ahead,
one,
go ahead.
which one are we going, is she going to be
where,
in
yeah,
now?
where is she parked now?
Where does the landlord want her to be parked now?
Where he told her to be parked,
Which is where?
in the middle.
Again?
In the middle, at
The
the
middle.
edge, yes,
On
because.
Concord Street, in the middle of the, okay.
Yes.
It's not close to the street. Yeah, que es lejos de la calle.
Ahí se puede
Okay.
ver.
No, we just want to get everything clear and understand.
I don't have any house closed, any.
Except there are some across the street.
Yeah, nothing, nobody.
All right. Anybody else in the audience have anything they want to say? Anybody from Zoom? Get back to the board. What do you guys want to do? This is, on this case is Meltzer, Johnson, Yan, and Len is the alternate. Johnson, Yan?
The hours seem long, like 10 is pretty late on that.
Yeah.
Again, if there is residential there, 10 o'clock, especially if you're gonna pack up and,
Yeah, I think maybe,
Stores.
maybe on Saturday she can go a little later, but earlier.
After dark?
Well, but then in the winter, it's dark at 4 o'clock in the
No, I
afternoon.
understand. If you're going to be operating until 10 o'clock at night, whether it's the wintertime or summertime, it's still going to be dark. What type of lighting are you using to keep whatever patrons would come, safe?
Usted, ya sea que trabaje ahí durante el invierno o el verano, a las 10 de la noche ya está oscuro. ¿Qué tipo de iluminación utiliza usted para mantener la seguridad de usted y de los compradores?
El building tiene luz arriba y la trailer tiene mucha luz. Yo puse mucha luz, como 4 luces arriba, que puede alumbrar todo. Sorry.
The building has a lot of lighting outside, and also the trailer has 4 big lights on the top.
I mean, light pollution is a big deal with me, I think.
Well, I think in any event, no lighting can be shining towards the houses on the opposite side of Concord Street. And we need to,
Si quieren pueden visitar el trailer.
You can visit my trailer.
I want to make a decision tonight.
so what do you guys think is appropriate hours
I think
during the week?
More like 8.
8 PM?
I mean, I don't know how much business does she have at
People at the office.
10 o'clock at
Most
night?
restaurants in Framingham close at 8 or 9.
Yeah, I mean, here's the thing is like the restaurants complain that food trucks are taking their business away. Or is people actually visiting her and at like 10 o'clock at night? I'm not sure.
Well, it's called competition.
Well, let's
It's
ask.
no competition, but, she has an advantage by not having to pay rent.
But she pays rent because she's.
Well, she's paying rent, but she's not paying, yeah, she's got other costs, I understood, but it's probably considerably less than someone who actually has a physical.
Well, so what hours are you comfortable with?
I'm comfortable with 8.
8 PM? Christina, how about you?
I think 8 p.m. is sufficient, and there's always an opportunity she could come back to us if there is, a particular need for her to be open maybe later on Saturday. But I think 8 p.m. to start is reasonable.
Okay.
I mean, Saturday, let's just keep it simple, 7 to 8.
7 AM to 8 PM?
Monday to Saturdays.
I want to tell us something, please.
Yes, of course.
Por favor, déjale. Hay muchas personas que piensan que estoy vendiendo. Y no es verdad. Hay días vendo 50. Hay días, yo estoy ahí de 7 hasta las 8. No puedo mentir, Dios es mi testigo. De 7 de la mañana a veces estoy ahí hasta las 7, no vendo nada.
I mean, people could say that I'm selling a lot, but sometimes there are days that I'm there from 7 a.m. to 7 p.m. and I don't sell absolutely nothing.
Nothing. Nothing.
Not good.
Nothing. Pero yo tengo fe que Dios me va a mandar que soy una persona. Si quieren, puede ir alguien a supervisar cuántas personas entran ahí diario.
Hold on, let her translate that, please. Cynthia.
I don't have any reason to lie, and someone can come and supervise in person. I mean, they can count the people that comes in that frame time.
No,
Sometimes I just have one single person coming, like, in the whole day.
Our concern is with the truck, I guess I should say, trailer being there, and
There's noise.
and there's extra light pollution and activity across the street from these homes up till 10 o'clock at night, and that's why we're thinking about 8 PM rather than 10 PM.
Mr. Chairman, I remember a case, it was the brewery.
Hold on, Cynthia, do you want to translate that?
La cuestión aquí es que hay veces que, bueno, lo que nos estamos cuestionando es que básicamente hay contaminación con tanta luz y el ruido y lo que puede generar con los vecinos. Los disturbios. Entonces, nos preguntamos si acaso cerrar a las 8 de la noche sería más saludable para todos.
Bueno, si me dicen hasta las 8, yo tengo que cumplir con ellos. Pero a veces a las 8 viene una persona, dame eso. A las 9, a veces mi primera venta viene a las 9. Pero si ellos...
If you say that I should close by 8, I'm gonna do it because you are the ones that authorize this.
Okay.
But sometimes my only clients come between 8 and 9 p.m. But I will do whatever you allow me to do.
Once they find out that you are closing at 8, then maybe they'll come earlier.
A lo mejor cuando usted ponga que va a cerrar a las 8, van a empezar a venir más temprano.
Estoy para obedecer a las autoridades. Dios sabrá todo. Dios sabe todo.
I'm here to respect whatever the authorities allow me to, and God will help me through this.
Appreciate that.
Maybe we can consider having her stay open until 10 on Fridays and Saturdays, and then up until 8 on Monday through Thursday. Because I know personally, like, I'll eat out usually on Fridays and Saturdays.
But you're young, us old guys.
How do you guys feel about that?
I'm open to it. I just want to remind a former, a case that we decided, Exhibit A in the beer garden. In which, does any of you remember that? And we limited hours, like, early because it was in a residential zone.
Yeah.
The beer garden did not play music, but there was people congregating and there was people talking. And we decided that we limited their hours on the weekends. I'm not sure if that's accurate, but, you know, that's a precedence that.
Do you
which we-
remember what we limited their
We
hours to?
limited, I think, Saturdays and Sundays to like 6 or 7, to tell you the truth. Because it was like, but the thing is, they were like butting right next to to residential. That's why they closed, because of us.
Maybe.
They had live music, by the way, at Exhibit A.
Say again, Christina?
They had bands and live music.
Yeah, oh, that's
So-
true. They did, but, you know, we limited their hours. I remember that distinctly when the talk of hours came here.
Christina, how do you feel about Monday through Thursday, 7 AM to 8 PM, Friday, Saturday, 7 AM to 10 PM?
I'm fine with that.
But even after that, if people are there standing around and talking, then we can't, at 10 o'clock, she can close the truck down, but that doesn't mean that people can't still be there talking and laughing and eating their food.
They could be anywhere talking and
Right,
laughing. and eating their
exactly.
food.
So 10 o'clock-ish is probably.
If you have something you want to say, I want to hear it.
I'll say something.
Okay, please do.
It feels kind of ridiculous. I mean, this is 126. This is not where Exhibit A is, which is all houses. This is Route 126 with all the streetlights and the traffic and all the other restaurants. There's a couple of buildings across the street that you don't even know are residences or not. You are completely speculating. If there were neighbors that had a problem, this is their second opportunity to come and speak up. Right? We had a counselor call and say it was the size of an 18-wheeler, and he's getting all these calls from neighbors. The whole thing is BS. It's not the size of an 18-wheeler. And where are those neighbors if it's really bothering them? What kind of noise is coming from a speaker this big? She couldn't have said it more times, right? We're on a major road, and people in her culture eat later than people in our culture. It's her whole business. So basically, you're running her through the ringer and making it as hard as possible for her to operate when you have all these other food trucks around town that aren't being regulated at all. Let's give her a chance. And how about if you find it's disruptive, then you come back, right? Rather than making her come back over and over for these hours-long sessions with the translator. I mean, where's the common sense here?
This isn't a popularity contest, either now or later, so, and you may not appreciate that, but if you lived across the street, you may feel differently.
You don't even know if anybody lives across the street. You're literally making it up.
I'm not making it up, and
She doesn't think there are
okay.
she thinks there's businesses across the street, and she's the one who's there every day.
I see houses across the street. I'm not making it up. My office was on Concord Street, 2 doors down in this location for 18 years. Not making it up. I know what happens on Concord Street. And I don't appreciate the characterization. I really don't. If you want to be factual, be factual. But an ad hominem attack is really has no place here. Suze, why don't you go ahead? Is that Suze Craighead?
No, it's not.
Okay.
No, I was just going to say that.
It is Suze Craighead.
Of course it is.
Okay.
No, I was just going to say that, nobody's asked her who are her customers later in the night. They may be people who are working at Home Depot. They may be people who are working someplace. And just turn off the music, after a certain period of time, and, give her a temporary approval and see what happens.
Okay. Thanks, Suze.
Take care. You're doing great.
Anybody else? All right, back to the board. What do you guys want to do? I mean, I have obviously a condition that there's no music or loudspeakers external to the trailer,
I can make a motion.
only parked where designated, as indicated during this hearing. I'd like something that there's no lights that'll shine towards the houses on the opposite side of the street, and then something about hours of operation.
I can make a motion.
Okay?
I will make a motion to grant this use variance based upon the conditions of Monday to Thursday, 7 a.m. to 8 p.m., Fridays and Saturdays, 7 a.m. to 10 p.m., on the conditions that there is no exterior speakers and no extra lights other than what is on site and what is indigenous to the food truck.
Okay. Christina?
I'll
any thought?
second that.
Okay. Okay, so we have a motion, and we have a second. Is there any further discussion? All those in favor of granting the use variance on those terms and conditions? Christina?
Yes.
Lap?
Yes.
And I'm a yes. We're not done. We do need to make a decision with regard to the appeal, and we can uphold the building commissioner's decision, and it won't have an effect on the use variance, because the use variance allows her to do this going forward, and the building commissioner's determination would stand in that circumstance.
I mean, she's just,
But we have the petition before us, we have to make a decision.
We should uphold the building commissioner's decision.
I think,
as much as it pains me to agree with that, I think we should uphold it because technically the building commissioner was correct in issuing that violation.
okay, so is there a motion?
I will make a motion.
I'll make a motion that we uphold the decision of the building commissioner.
Thank you, Christina. Is there a second?
I will second it.
Okay, motion and second. Any further discussion? Seeing none, all in favor of the motion? Christina?
Yes.
Lap?
Aye.
And I am yes. Okay. Cynthia, could you give her a summary of what we just did, please?
Señora Lacroix, ¿le comentan ellos o hicieron ellos la aprobación de las variantes para que usted abra su negocio de lunes a jueves de 7 de la mañana a 8 de la noche y viernes y sábados de 7 de la mañana a 10 de la noche? Con las condiciones de que usted no va a tener bocinas en el exterior del negocio que estén transmitiendo música a alto volumen o luces adicionales a las del edificio y a las que tiene su tráiler de comida. Pero a la vez ellos acaban de aprobar de manera unánime la apelación de la decisión del efecto de permitir al comisionado lo relacionado con el edificio.
Okay, so in the next 14 days, we will issue a written decision and record that with the city clerk's office. You will get a copy of that, and you'll need to record that at the Registry of Deeds. And then there's after 20 days, you'll be able to record that at the Registry of Deeds, so long as nobody appeals that decision.
Stephen, I don't think the hauling off out of the trailer was in the motion based on her translation.
Oh. That's right, there wasn't a condition that she remove the trailer nightly in your
Yes.
motion. So do we have whose motion was it? Was it Christine's? Yeah, it was yours?
I will amend that motion to include the trailer being pulled off-site every day.
Okay, Christina, you still there, Christina?
Yeah, I'm still here. Don't we have to rescind the original motion and revote?
Yes, you do.
Sure. Do you have a motion? Go ahead, make a motion to rescind, and we'll take care of it that way.
Such officious.
Okay. I make a motion that we rescind the original motion to approve.
Okay.
I'll make a second.
Okay, motion and second, all in favor of rescinding the vote to approve?
Aye.
Christina?
Yes.
And I'm a yes. Is there a new motion?
Do you want to do this, Christina? Because, like I said, yeah, my age, I've forgotten everything already.
Well, how about this? Would you like to make a motion to incorporate the conditions that you stated in your first motion and adding to that the requirement that the trailer be removed each night after closing and removed from the property?
I will make a motion to.
Yes, so moved, say.
So moved.
Okay. Okay, so there's a new motion.
Second.
And there's a second. Any further discussion? All those in favor?
Aye.
Christina?
Yes.
And I'm a yes. So we have a fixed decision. Cynthia, what's that?
Señora Lacrosse, ellos ahora acaban de aprobar la moción de que incorporar la moción original en la que le dictan a usted que tiene que estar moviendo su tráiler de ida y de venida todos los días.
Okay?
Okay, thank you. Gracias.
All right, you're all set then.
Thank you.
Good luck.
And Cynthia, just thank you very much for helping out with this. Muchly appreciated.
Thank you so much.
If we need
Yes,
another
thank you.
Spanish translator, can we call on you?
Yes, of course.
And Francis, thank you.
I'm sorry, but I didn't tell the Mrs. Lacrosse about the 14 days. Is that something that you are gonna print for her so she knows
Yes,
those?
Yeah, she'll get an information sheet from the
Okay.
administration office.
Okay. Thank you.
All right, thank you very much. Okay,
Pulling teeth.
25, 29, 356, and 368 Salaman Road, AKA 334 and 344 Salaman Road. We've received a lot of information since the last hearing on this, both by email and otherwise, from interested parties, neighbors, members of the community, the proponent of the project, as well as the official opponent of the project who brought this appeal. You can assume that we have read all those materials and are familiar with them. And you can also assume that, we remember what everybody said last time you were here. So there's not any need to repeat yourself. I would remind everybody that I will need you to stay relevant to the decision we have to make. But otherwise, I invite the proponent, or actually the, why don't we start with the appellant? Let them summarize if they wish, and to the extent they wish, any changes or any additional information that they'd like us to hear. Then we'll hear from the proponent of the project, and then from anybody in the audience who wishes to speak. Francis is recusing himself on this matter, and he's going to step away for that purpose. So, sir, the floor is yours.
Good evening. I'm Neil Glick, attorney for David Abramson and Joe Bonanno, both long-term residents of Cherioka Road and both direct abutters to the proposed project at 334 to 344 Salem End Road. My clients are the appellants, as you've just noted, of the decision of Commissioner Bray that the project qualifies for an override of the Framingham zoning ordinance provided by the Dover Amendment. That's the issue before you, and we raise it with respect to the commissioner and his work, as we mentioned last time. So I'm going to start on a positive note. I wholeheartedly agree with my opposing counsel for Pure Life Development LLC that the board has been provided with extensive legal arguments on both sides. You've been literally bombarded with case law and the like. So what I seek to do tonight is to focus the board on the facts of the project, the relevant law, and the legal test to which those facts must be applied. And ultimately, then, when you use your good judgment to urge you to apply that legal test, to urge you to find that you simply cannot determine that this project qualifies for the override of the zoning ordinance under the Dover Amendment. So first on the facts. Fact one, who is your project applicant? This is an easy one. It's Pure Life Development, LLC. The attorneys for Pure Life, who, by the way, are the same attorneys who now represent the so-called Health Education Charitable Foundation, Inc., applied on behalf of their client, Pure Life. They identified their client, the applicant, not once, not twice, but 3 times over a period of months to Commissioner Bray for Dover Amendment protection. Pure Life was the only applicant that Commissioner Bray ever saw or knew of. When Pure Life submitted plans to Commissioner Bray, the title sheet on those plans, dated July 29, 2025, identified the applicant as Pure Life Development, LLC. When Commissioner Bray issued his Form B decision concerning the applicability of the Dover Amendment, he specifically referenced those plans dated July 29, 2025, again describing Pure Life as the applicant. When Commissioner Bray issued his Form B decision on the 25th of November, it was for the owner of the property where the project was being built. That owner then was Pure Life. It was not until almost a month later, in mid-December, that Pure Life suddenly woke up, realized that the Dover Amendment requires that the applicant be a nonprofit, and then conveyed the property as a gift for $1 to a hastily formed empty shell entity called the Health Education Charitable Foundation, Inc. In short, Commissioner Bray did not make his decision based on any applicant other than Pure Life. He simply could not have done so. Similarly, Pure Life suggests somehow that NECC is your applicant. NECC has had its chief financial officer speak to you. They have submitted an affidavit. The attorneys for Pure Life, in their submissions to you, singled out and praised NECC, but NECC has never pretended to be your applicant. Not now, and certainly not before Commissioner Bray. On the contrary, NECC's only contact with Commissioner Bray was a single, very brief letter from its CFO, not an educational officer, but its CFO, that was submitted, quote, at the request of property owner Pure Life. That letter made reference to a provision in a, quote, lease to NECC from Pure Life. NECC never described itself as the applicant. They never even pretended to be the applicant. And by the way, in terms of facts and applicants, the facts concerning the foundation are not particularly good. As we have previously pointed out, the foundation has no website. They operate out of a suite in an office park in Waltham. That suite is occupied by business entities associated with Tony Kwan of Pure Life. It appears to be a mail drop. There are no programs, grants, or other activities of the foundation that appear online. It is indeed a shell. Fact number 2, the lease. At the last hearing, you stated that you wanted to see the lease. You did not get it. 2 days ago, you received a heavily redacted version of the first 39 pages of the lease. That's a lease that is likely at least 60 and probably more like 70-plus pages, including exhibits. If one accounts for the redactions, you received 6.1 pages of those first 39 pages, or about 15% of just the 39 first pages. 32 of those pages were skipped entirely. Not a very robust or particularly informative disclosure. What's in those few redacted pages that were produced? Well, there's a section entitled Agreement, but we do not get to see the terms of the agreement. That's all redacted. We do not have definitions of key terms. For example, does tenant include NECC or any affiliate of NECC, such as its organizations in foreign countries, or companies that might purchase NECC? We don't know. We see that the initial term is 20 years. Compare that, please, to the useful life of the building proposed, which is likely many, many years longer than that. There are 2 possible 5-year extensions, but those can be for, quote, any affiliate, end quote, of NECC. In short, we don't know who the city would be dealing with in later years. We learned nothing about what is to be built. The application filed by Pure Life was for 47 units, but the lease allows up to 100 bedrooms. That's all they specify. The building is simply defined as a residential building in an urban neighborhood. Is Salem End Road an urban neighborhood? There are references to, quote, architectural plans and specs, but they're not attached, and a, quote, construction management plan, but that's not attached. We do not know what the base rent is, and we have no idea what any additional rent might be. Under permitted uses, and this is key, we learned that the project is not restricted to teachers at NECC, as you have been led to believe. No, it's for housing for staff. That's a direct quote, housing for staff. This could include security guards, custodians, accounting personnel, IT workers, literally anyone. The tenant can decide who leases the apartments to either staff of NECC or any affiliated nonprofit. How about the staff of some nonprofit that has absolutely nothing to do with education? All of the talk that you heard last time about heroic teachers of NECC and, quote, without teachers there can be no education, end quote, it turns out to be just talk. It's not true. And here's my favorite part, the completely circular reasoning. The permitted use is limited to uses that qualify under the Dover Amendment. So they're essentially saying that, quote, don't worry, the use of the project will always qualify under the Dover Amendment because it must be a use that qualifies under the Dover Amendment. It's just a circle. They're just saying, just trust us. But who gets to determine that? Not Commissioner Bray, not any city official, not anyone in the neighborhood. How on earth can this be policed? Tenant is allowed to permit the use of the premises on any portion thereof to be used by the, quote, general public, as long as there are, quote, restrictions. But what does that mean? We don't know. Who polices it? Tenant's interest in the lease can be transferred as long as landlord consents, while landlord's consent can be withheld if landlord determines that the transferee is a qualified entity under the Dover Amendment. But again, that's just circular. And who polices that? There is a right of first offer whereby a tenant may be able to purchase the property, but all of the major terms of that offer are redacted. We do not know much about this right. We frankly know almost nothing. And of course, then we skip the remainder, tens of pages of the lease in its entirety. We do not know what we do not know. We cannot see what we are not allowed to see. Next fact, the project itself. The project includes an incredible combination of Dover-related factors, a sort of perfect storm, if you will. Some of these factors may have been individually litigated under Dover Amendment cases, but the combination of these factors has never been litigated. The factors are an alleged educational use on new construction on vacant land, of a residential housing structure not designed or built as an educational building or on an educational campus, but rather as a standalone, standard multifamily housing project, to be built on private property owned by a for-profit applicant, Pure Life, located not just outside of any campus or any core campus, as some of the case law requires, but several miles away from that campus in a different municipality and even in a different county, to be occupied perhaps by an educational entity pursuant to a lease that Commissioner Bray never saw and you have only seen small snippets of. And it's only for staff, it's for staff housing, not for teacher housing. And no educational activities are taking place on the project site. None. They're specific about that. Now let's apply the law to these facts. There is no case that Pure Life or the Foundation has provided to you that is based on the application of a for-profit entity, let alone a for-profit developer. That's because in the 60-plus years of Dover litigation, no such case exists. In all of the cases brought to your attention by both sides, the applicant was either a nonprofit, religious, or educational entity or a political subdivision of the Commonwealth. That's for a good reason. The Dover Amendment was not meant to be a tool for developers who use some kind of relationship with a nonprofit to build their project. It was meant to be a tool of nonprofit, religious, or educational entities. Here you have a for-profit developer as your applicant. That alone mandates the reversal of Commissioner Bray's decision. I've demonstrated that Commissioner Bray based his decision on the ownership of the property with the application before him of Pure Life. He could not have done otherwise. That's just common sense. Moreover, I have provided you with an appellate court decision, Selco v. Peabody, which directly states that, quote, we do not scrutinize decisions of local officials in light of events that occurred after those decisions were made. So you can't look at subsequent conveyances to a shell charitable foundation. So the law for a change follows common sense. On top of that, I provided you with 2 trial court decisions in the Superior Court and Land Court, which follow the Selco rule in the Dover Amendment context. In response, Pure Life's attorneys simply state that these arguments are, quote, unserious. They say they're full of, quote, doubt. They say they're tendentious. In so doing, they cite no case law to support these unsupported claims, thereby demonstrating that, in fact, it's their rebuttal that actually fits their own description. It's pure projection. There is no case law that Pure Life or the Foundation, for that matter, has provided to you, which is based on all of the factors, that perfect storm that I described, as being applicable to this project. That is because, again, in the 60-plus years of Dover Amendment litigation, no such case exists or even comes close. Sometimes one factor is mentioned or even relied on, and Pure Life cherry picks that factor But never do we find that the combination of all or even many of these unique factors that this project involves are part of the decision. Not even close. None of them involve a for-profit developer and owner of the land in question. None of them deal with a nebulous and undisclosed lease to a non-applicant educational entity in a different municipality in a different county. None of them address faculty or staff housing in isolation, untethered to any educational activity or purchase. All of the education cases concern projects that are an integral part of an educational campus or where the project literally is the campus. It's a single building that is the campus. That's the project. None of them deal with new construction on vacant land in a different municipality or county. In short, Pure Life cannot simply cobble together disparate cases that might reflect one or more aspects of its project and then claim some kind of synergistic conglomeration of those disparate factors that justifies its project. The cases cited by Pure Life simply do not fit the situation actually proposed, the perfect storm that I described, of problematic Dover Amendment factors. There's a clear test, and Pure Life cannot pass it. In 2012, the Supreme Judicial Court recognized the Dover Amendment case law needed some clarification and guidance. That concern spawned the Regis College case. That case, still quoted in every Dover case, established a test, the second prong of which was that the primary or dominant purpose of the land or structure involved had to serve a primary or dominant educational purpose. It could not be mere window dressing. It could not be a smokescreen. It could not be just something thrown out to make it convenient or financially beneficial. The court actually used those terms, window dressing and smokescreen. That test has been applied ever since, and clearly Pure Life fails it. There is no, repeat, no educational activity that will take place on the proposed housing project. Any effort to shoehorn an educational purpose in what is clearly a merely extremely remote staff housing project is the very definition of window dressing or smokescreen. It's a shell game, just like the belated conveyance to the Shell Corporation. Pure Life's alleged educational purpose is simply an incidental financial benefit to it, to NECC and it. It is, as the court in Regis warned, quote, so amorphous, flexible, and vague as to constitute window dressing for a luxury residential complex. That kind of smokescreen of an educational purpose was rejected clearly in the subsequent recent cases that I cited of both the Superior Court and Land Court in the Dover context, in Kearsarge, Walpole, and Heritage Plantation of Sandwich. You've got those cases, and I know from the chair, having said he just read and probably memorized each one of them. Those cases rejected the application of the Dover Amendment and serve as precedent for your rejection of Commissioner Bray's decision. Now, I want to spend a little bit of time on the belated effort to use the Hume Lake.
You've been going a long time, if you could try and...
I will wrap up soon. I appreciate your patience. But there was a lot of stuff that was submitted at the last minute. The belated effort to use the Hume Lake case, after months of correspondence offering up 60 and 40-year-old case law to attempt to bolster its case, Pure Life suddenly discovered the Hume Lake case. Now, all of a sudden, in a desperation move, Pure Life claims that this case, quote, controls the outcome of this appeal and dictates a finding that the project benefits from Dover Amendment protection, end quote. It does not. In looking at Hume Lake, it's important to note that the Dover Amendment deals with both religious and educational structures. Hume Lake is a religious case. The courts have dealt with these two kinds of Dover projects very differently. Why? Well, Hume Lake itself tells us, quote, Notably, in determining whether a particular use of land or structures serves a religious purpose, we avoid making judgments as to whether a proposed use constitutes a necessary element of a particular religion, as that would constitute an area of inquiry that the First Amendment to the United States Constitution prohibits. You find the same kind of language in the Martin v. Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints that's quoted in Hume Lake. Obviously, in the educational context, things are very different. The First Amendment does not give constitutional protection to education. Further, Hume Lake dealt with a very small RV park in a Christian camp in a very rural setting. Pure Life claims that the RV park was, quote, somewhat distant from the rest of the campground, implying that it was, like the current project, a remote facility. But however, Pure Life neglected to include the rest of the court's that very sentence, which said, quote, but within walking distance of the other facilities of the camp. In other words, it was not a remote facility at all. It certainly was not miles away from the main campground facilities or in a different municipality. Other distinctions abound. The owner of property in Hume Lake was an established multi-state nonprofit religious organization. It was the applicant and the operator of the entire camp, including the proposed RV park. It did not lease the RV park to a third party. The RV park was proposed as an integral on-site part of what the applicant owned and operated as part of its Christian camp. The RV park was for a whopping 12 RVs, not a large 47-unit multifamily housing development. Simply put, Hume Lake fails to control the outcome of this appeal. It really has little or nothing to do with the proposed project on Salem End Road. Similarly, the undated guidance of the Attorney General submitted by Pure Life is by no means the, quote, authoritative treatise that Pure Life now suddenly claims it to be after months of ignoring it. It is, by its terms, nothing more than a summary written as a general survey of the law under the Dover Amendment with no connection to any particular set of facts. Even Hume Lake, along with several other cases, states that, quote, exemption under the Dover Amendment is a mixed question of fact and law. As the guidance is explicitly general in nature and does not deal with any specific set of facts, it cannot control your review and analysis of the particular facts of this case. It's also not legally controlling. Even actual opinions of the Attorney General, which by statute can be provided to certain state departments, are not binding on a court. As the Supreme Judicial Court held in Mahajan versus Department of Environmental Protection in 2013, quote, courts retain the power for themselves on a case-by-case basis whether or not, and if so, to what extent, the courts agree or disagree with an advisory opinion of the Attorney General as to the proper interpretation of some issue of law. Similarly, this undated, unsigned, general survey of the law under the Dover Amendment by the AG's office cannot and should not control your deliberations concerning the particular project before you. So in conclusion, I'm getting there. The applicant is a for-profit developer. That alone justifies reversal of Commissioner Bray's decision. The applicant can't rely on the lease because they have not provided the lease to you. And the snippets of the lease provided just create more questions than answers. The applicant fails to meet the established legal test. The purpose of this project is not predominantly educational. It's not educational at all. So the decision of Commissioner Bray, we would ask, it must be reversed. Thank you.
Thank you, Mr. Dorff. Again,
Gotta give it equal time now.
Michelle, go ahead. You don't feel like you have to use as much time as Mr. Glick.
Thank you. I will hopefully come in under that. So I don't have as much experience with the Dover Amendment, and admittedly, I did step in for a far more experienced counsel just to deal with this appeal while he is recovering. So I apologize for not bringing Hume Lake and the AG's guidance to the board's attention earlier. However, I will note that Commissioner Bray, at the beginning of last meeting, specifically cited the Attorney General's guidance as one of the key sources that he relied on in forming his determination. And the reason that the AG's guidance is so critical here is because Mr. Glick and I are both doing a job advocating for our clients. The Attorney General's office has put this guidance forward, and it is recent guidance. It, quote, refers to, for instance, Hume Lake, which is a 2023 Supreme Judicial Court decision that postdates all of the case law cited by Mr. Glick. That is put out as a neutral advisory for members of the public and for municipal bodies to understand the state of the Dover Amendment law as it applies to religious use and to educational use. And I will note, in that guidance, the AG specifically calls out that these principles are generally applicable across the board in Dover. Religious use and educational use is afforded the exact same protection under Dover. They're in the exact same paragraph. They're referred to in the exact same sentence. Yes, the First Amendment does protect religion from second guessing in a way that perhaps educational use does not, but for Dover Amendment purposes, they are treated exactly the same. So we suggest to the board that where Mr. Glick and I are both advocating for our clients, the AG's guidance should be referred to by the board as the neutral standard, as a statement of the law and summary on which this board can rely. Further, while we will concede it is certainly not binding on the board or on the court, there is not one single aspect of the advice in that document that Mr. Glick has called out as incorrect. So the narrow question here is, does the Dover Amendment apply to a lease to NECC for the exclusive use for its staff housing? There is only one answer that can be reached, and that is yes. The AG's guidance cites a two-pronged test and states a two-pronged test for whether Dover applies. And this citation in their guidance is to both the Regis case and to the Hume Lake case. First question, and the answer to both must be yes. Is the land owned or leased by a religious sector denomination or a nonprofit educational corporation? The answer to that is clearly yes. You have the lease. You have you have everything in the lease that is relevant to your determination today. How much is paid in rent is not relevant. What other provisions are in there? There's a lot of boilerplate in a lease, which would be wasting this board's time. And frankly, a lease imposes obligations on both parties. It has dispute resolution mechanism. It has a lot of stuff in there that, given the level of animosity towards this project, can be picked through and spun in a bunch of different ways. But you have absolutely everything that is relevant here. You know the tenant of the lease, New England Center for Children. I don't think anybody in here disputes that that is a bona fide nonprofit educational corporation. You know the term of the lease is 20 years with 2 5-year extensions. You know that there is a right of first offer. You know that the use is restricted to staff housing and to other Dover protected uses. The only subletting that is permitted is to sublicenses for residential use by NECC staff. There can also be a transfer or an assignment to an affiliate, a subsidiary of NECC for Dover protected use, and with landlord's approval, and only with landlord's approval, to another Dover protected user for a Dover protected use. No more is needed and no more is relevant. You also have the First Amendment to the lease. You have the waiver by NECC of its right of first offer on the transfer to the foundation. you have the assignment and assumption agreement between NECC and the foundation. And while frankly not relevant to this board's determination, I was informed this evening that the foundation has been granted 501c3 status, and I have emailed the notice from the IRS to the ZBA email address during tonight's hearing. I apologize we didn't have it for you sooner, but again, it's totally irrelevant who owns the property as long as it is leased to a Dover protected entity. There can be no dispute that NECC is such an entity and that the lease exists. Frankly, I could own the property, Mr. Glick could own the property, Strawman LLC could own the property, Window Dressing Incorporated could own the property. It does not matter because the statute specifically calls out land leased to a Dover protected user. So the second prong of the test, a bona fide religiously or educationally significant goal is the primary or dominant purpose for which this land will be used. Again, the answer to that is yes, and I'll spend a little time explaining why. It is clear under the Dover Amendment case law that ancillary structures and uses are protected even if they are not religious or educational in and of themselves, so long as their primary and dominant purpose is the support and advancement of a Dover protected user's Dover protected mission. Educationally significant uses are not limited only to those facilities closely analogous to traditional schools. Instead, courts have found an educationally significant goal for the purposes of the Dover Amendment when an ancillary structure supports the work of an educational institution. And that's at page 4 of the AG's guidance. It's common for religious or educational goals or activities to be intertwined with other goals and services, including housing. And courts have repeatedly cautioned against trying to draw fine distinctions between the aspects of an applicant's program in assessing whether the Dover Amendment applies. The primary or dominant purpose test does not turn on how much of the square footage, how much physical space is devoted to a religious or religious or educational activity, because ancillary structures like parking lots, like snack shacks at a ball field, like field lighting at a ball field for a secular educational purpose, are still Dover protected under binding Massachusetts law. Frankly, the test that you're being asked to apply by the appellant here is backwards. It's clear that Dover protection applies to uses that are ancillary to education, but have the primary and dominant purpose of supporting the work of an educational institution. The cases that you have been given by the appellants here are not ancillary to an educational use. It's the opposite. They are a primary non-educational, non-religious use to which a minor ancillary educational component has been attached. So for instance, a YMCA fitness club is not Dover protected because it happens to also offer exercise classes, much like any commercial gym. An alternative medicine clinic cannot establish educational use merely because it offers workshops in alternative medicine. A utility scale solar project is not protected as an educational use because it will also involve some curriculum for a local vocational school. And placards at a ropes adventure course that include a description of the physics involved and the operation of gravity and momentum cannot change that recreational use into an educational use. What we have here is the opposite. So a number of questions were posed by the board and by the public at the last hearing. Relevant provisions of the lease have been provided. There can be no serious argument that this property is not leased to NECC, that the lease does not exist, and that it is not for staff housing. Does it matter if the landlord is considered the foundation or Pure Life? No, it does not. As I said before, it could be me, it could be Mr. Glick, it could be anyone, as long as the lease is to NECC. Can the board consider whether housing in this location at this facility is a need to have or a nice to have for NECC? No, it cannot. It's not within the board's authority to deny Dover protection based on a subjective belief that NECC could have made a better choice where to pursue housing. As explained in Hume Lake, the focus of Dover Amendment analysis has never been on an organization's reason for choosing one means of pursuing its goals rather than another. Rather, we look to the purpose of the particular use to which the land or structure is put. Here, the reason Hume wanted to house workers in the RV camp is so that their labor may assist the camp in carrying out its religious goals. Accordingly, this use of the RV camp would serve a religious purpose. Here, NECC wishes to use the facility to provide housing for its teachers so that it can recruit those teachers, take advantage of their labor to provide education for their students, and frankly, it could be the super, it could be the maintenance worker, it could be the accountant, it could be Mr. Downey, the CFO who lives there. If the purpose is to provide housing for employees so that their labor can advance the goal of the educational institution, it is Dover protected under Hume Lake. Again, this exclusion of making a value choice of whether it's a need to have or a nice to have is consistent with Dover law. There is the Martin case where a steeple is not, regulation of the height of a steeple was deemed to violate the Dover Amendment. Once a determination is made that a structure serves a religious purpose, no further inquiry as to the applicability of the Dover Amendment was warranted. The crucial case here is Bible Speaks versus Board of Appeals of Lenox. That's a Massachusetts Appeals Court case from 1979 that is frequently cited and remains good law. And essentially, the appeals court ruled that local boards may not engage in campus planning by deciding what is or is not necessary for a Dover protected use. The town argued in that case, Dover should not apply to the installation of lighting at the softball field at the school because playing softball at night was not reasonably necessary for the function of the religious or educational uses. That was struck down with the court saying the board is essentially pursuing its own notions of land use planning, and to the extent those notions become inconsistent with the presence or expansion of educational institutions within the town, that would violate Dover. Excuse me. What happens to the property when the lease ends or NECC leaves? And related to that was, is this now a pre-existing non-conforming use that this can be residential forever? And the answer to that is no. A Dover exemption for a use that is not allowed under zoning does not carry the same precedential value, does not transfer to a subsequent owner as a pre-existing non-conforming use. This is in the AG guidance, page 16. Prior non-conforming use to have that protection must predate the bylaw that regulates whatever that use is that is non-conforming. Here, the bylaw predates this project. There is no further protection for any non-Dover protected use thereafter. At such point as the property is no longer being used by NECC or the lease expires, The property will be governed, the use of the property will be governed by whatever zoning is in place at that time. If it's still a single-family residential district, there either must be a Dover protected use that comes in afterwards, or it will no longer be able to use for that purpose. Can the ZBA impose a bond requirement for removal of the building at the end of the day? The answer to that is also no, under the AG guidance, page 17. Municipality cannot impose mitigation fees on a Dover protected use unless there is some statutory authorization to do so, and that would come in the realm of the categories that are permitted for municipal regulation of a Dover use. That's not before the board today. That's a question for the planning board when this project goes for minor site planning review. And further, where Dover protection or a Dover exemption does not carry over to a subsequent user, like a pre-existing non-conforming use, there's no need for a bond requirement. Zoning will apply at such time, and at that time, there either will or will not be a Dover protected user. So finally, the big question, does the Dover Amendment protection apply for this project that will be used for housing employees of NECC? And the answer is absolutely, unequivocally, yes. Under prong 2, a bona fide religious or educationally significant goal is the primary purpose for which this land or structure will be used. You heard on February 11th from NECC's CFO, Michael Downey. He testified there are 3 categories of staff of NECC that are eligible for subsidized housing: international staff on work visas, graduate assistants who work for NECC and are also enrolled in one of its master's or PhD programs taught on their Southborough campus, and new recruits who are relocating to Massachusetts from around the country and don't have local roots here, don't have friends here to find an apartment with. They currently provide housing to over 100 employees. And he testified that NECC loses money by providing housing to its staff. It's administratively burdensome, it is expensive, but it is absolutely necessary for the school to recruit the staff and retain the staff, without which it cannot function. I encourage anybody who doubts the veracity of this to review the video recording of February 11th at the 1 hour and 42-minute mark. Mr. Downey testified, "Without a source of housing, we would lose the ability to recruit those staff." He went on to say, "There's nothing I'd like better than to get out of the housing business. If we got out of the housing business, we would not be able to staff our program." And so we've heard a lot about various cases that deal with student housing alone, mixed student and faculty housing. We've heard about on-campus and off-campus. There is one case that synthesizes all of this into a single decision and deals with different categories of housing, categories that are split up into the beneficiary or the party attending, or so in this case, it was the campers and the people attending the religious camp that are equivalent to the students of NECC. And I don't think there's any dispute that such housing for attendees of a religious program or students at a school is protected. Here, the RV camp was designed to house 3 categories. They're the attendees and their families. There are volunteers who travel there and provide labor for free. And there are seasonal employees, paid workers for the camp. The local board denied the application across the board, saying that housing is not Dover protected, housing is not a religious use. The land court took the position that Mr. Glick would have you take today. RV housing for camp attendees was Dover protected, but the land court concluded that Hume's purpose in allowing volunteers and seasonal staff to use the camp was primarily financial, therefore not protected by Dover. The camp appealed, and the SJC took the appeal directly to itself, skipped the appeals court, and overturned the land court judgment, finding that because Hume's proposal to build an RV park has as its primary or dominant purpose a religiously significant goal, the RV park in its entirety would be an exempt religious use. The purpose of the camp would be to facilitate the operations of and strengthen attendance at Hume. As is the case with Dover's protections for educational uses, the religious purposes exemption covers any use, the primary or dominant purpose of which is to aid in the system of faith and worship or to aid in the mission of an educational institution. And that's Hume citing to Regis, the case that Mr. Glick would have you believe controls here. And Regis is relevant, but Hume is on point. The exemption encompasses a variety of accessory uses that, while not inherently religious in nature, are components of a broader religious project that facilitate the functioning of that project. Again, that's the SJC in Hume. By way of example, they noted a church parking lot can be said to serve a religious purpose, just as a snack bar on a school softball field may serve an educational purpose. Unambiguously, housing for workers was deemed Dover protected. The primary or dominant purpose of housing volunteers and seasonal staff at the RV camp would be to facilitate the operation, maintenance, and improvement of Hume NE and thereby support Hume's religious mission. The primary and dominant purpose of the project before you today is housing the staff of NECC so that they are able to facilitate NECC's mission of caring for and educating people with profound autism. Volunteer housing was protected because even though Hume's goal is for Hume to
Michelle,
benefit.
Are you getting close to?
I'm page and a half and I'll speed it up. Are to benefit from their labor, volunteers are a critical part of the business model of Hume NE and heavily relied upon to perform work such as assisting with outdoor projects and maintenance. And it saves, just having 2 people stay in that housing saves approximately $8,600 annually. Paid employee housing, seasonal staff is protected because they perform work that is necessary to the camp's operations. Like we said before, you cannot teach without teachers. Hume is the SJC endorsing the circular logic that Mr. Glick is criticizing. The religious organization, and this applies equally to an educational organization, may depend upon secular tasks or non-educational tasks, such as the provision of food and housing in order to operate effectively. That is a bona fide educational goal. That is Dover protected. You have heard and you will hear a lot of criticism as to the nature of the project, as to whether the location is appropriate, as to whether the design is appropriate for the neighborhood, as to parking, as to traffic, as to a great panoply of concerns. None of those are relevant to your determination here today. Some of them may be relevant to site plan review or to land disturbance permit or stormwater management down the road, but they are not relevant to what is before you today. Commissioner Bray did his duty. In the face of very strong and passionate public opposition, he took a dispassionate view of the facts and the law, and he correctly applied them. None of the opponents of this project should be upset with Commissioner Bray, should be upset with this board, should be upset with anybody in municipal government, from the janitor to the mayor, if this board upholds Commissioner Bray's decision. The only legitimate grievance is with the legislature for having enacted Dover, under the Dover Amendment, such broad protections and exemptions for educational use. Any grievances should be brought to the general court, not here. We urge you to do your duty as Commissioner Bray did his. and deny the appeal and uphold the project. Thank you.
Thank you. No. Nope.
Briefly.
Nope.
Briefly.
Nope. Nope, nope. It's my turn. And I'm going to be brief before we go out to the audience, hear from the other board members. You know, as I alluded to before, I've spent a lot of time understanding Dover in my past life, starting many years ago. But I did have to reread everything in light of the facts here, and all the cases presented by both sides, and read the cases that they cited and how they were cited. And I would disagree with you, Mr. Glick, that Hume is instructive. I would say it is instructive. But I would also disagree with Mr. Michel. I don't think it necessarily is instructive in the way that he hopes. And if I look at Hume itself and the difference between religious use and educational use is an important one as we understand how these cases are analyzed. And one important thing stands out for me in the Hume case, and that is that the Hume RV camp or the Hume Lake program was a, quote, camping ministry. And the people who were engaged in living in the RV camp were the people who were part of that ministry. They were who would be, in the sense for the educational use, the students, not the teachers. The RV camp in Hume was not for the ministers, it was for the people who were a part of the program. So I would say that Hume really supports the idea that this use is different than the Hume use. In Hume, it was a camping ministry which was crucial and part of the very religious program, the camping aspect and the RV aspect of it. And here it's not. I look also, so Hume is one where they found that it was Dover, a Dover protected use, and I think this can be distinguished from that. Another one I look at is Worcester Dynamo. It's a very short case, very to the point, and it also found that that in that case it was a religious use that was found to be protected by Dover, in which they gave interns housing, living quarters, but the interns themselves were the program. They were the subject of the program itself. The students here are the subject of the program, not the teachers. So those two are very, very instructive for me, and they lead me to the conclusion that this is just a benefit, an employee benefit that that NECC wishes to provide in order to better recruit and train or better recruit its employees. It has no direct connection to the program that NECC has as its core. I do agree that it would have been more helpful to see more of the lease. I don't necessarily think it matters when it comes down to it for me. And you know, let's play for a minute. Let's play a little bit of a game of slippery slope. Does the proposition that an ancillary service for staff, which may be quite beneficial for NECC, is protected under Dover? Does that mean that anything that NECC wanted to put on this piece of property or on any property would then be protected if it was in the service of providing a benefit that NECC decides was crucial for their program. And we could run that hypothetical out to its absurdity. You know, what if NECC decided that because all of its staff were driving to and from work, that they needed to provide mechanic services, and they wanted to build a garage on this property? Wouldn't that have the same analysis? That's hypothetical, and I'm not looking for an answer, okay? But for me, the answer is yes, there would be no distinction there, or any other use.
I think that's a good analogy because there is a relevant distinction.
Excuse me, if I can't speak.
Oh, yeah, you're right.
If I can't speak, then Mr. Michelle can't speak. Exactly.
It's still my turn, so I had to sit and listen, and I didn't interrupt you until the very end. So that's where I'm thinking, that's where my head is at. And you know, I don't want to spend too much time further. I want to let the other board members have their chance, and if there's anybody in the public who wants to add to that, I want to hear from them. Again, new information only. But my last thought is this, you know, I look at Regis, and Regis is an important case, but I think that everybody seems to miss the most important lesson from Regis, and that is Regis College, which enjoyed a long relationship with the town of Weston and the surrounding towns, went through this process, fought hard to win these cases, ended up winning at the SJC, had the ability to do what they wanted to do, but didn't do it. And we can only wonder why, but maybe the lesson there is that they didn't want to further jeopardize their relationship with the community. And I think that's an important lesson. You know, NECC, I would think, and in my own mind, has for many years enjoyed great goodwill with Southborough and the communities around it, including Framingham. By pursuing this project, I think they burned through a lot of that goodwill, frankly. They do for me. Not that that's directly related to this analysis, but it is, in my mind, an important lesson from what happened in the Regis case. So, other board members, give you an opportunity.
Give Christina first, or?
Christina?
She looks like she wants to speak.
Go ahead, Christina.
Hi, I guess I can kick it off. Sorry, I just happened to look, I'm on a cruise ship. I just happened to get distracted by another cruise ship.
Rub it in.
The Queen Victoria just left port. I, like Chairman Meltzer, have worked with the Dover Amendment before, obviously in a different capacity, being a municipal planning professional. I did take the opportunity, actually, while I have been away, to revisit the seminal cases that have been cited, reading the legal briefs, and also taking the opportunity to read the public comments that have come in. So I also share Chairman Meltzer's perspective. I'm not going to repeat everything that's been said. Where I am landing at this moment is that the proposed staff housing is incidental to the educational use. I believe that the two-prong test is failed at this point in time, and that the staff housing is a benefit, and it's not related to it's not serving as the core primary educational use. So that is where I'm landing at the moment. And again, this is after revisiting the holdings of those seminal cases. I just don't think that this proposed use is protected under the Dover Amendment.
Matt?
I went at it in a little more quantitative. As you all know, I'm a quantitative guy. So the core question to me is it a nice to have or is it a must have? Okay, even though the attorney for New England has said it's a must have, I'm not convinced of that. And the way I go about it is I looked at the Form 99. For those of you guys who don't know what that is, that's basically like their tax forms that they filled out. So New England Children's Center has a revenue of $131.5 million, which grew considerably from 2000, the previous year. And they have, I think they made a net, I would say profit because they're a nonprofit of close to like $2 million this year. And that's great. All nonprofits should operate, like Harvard makes billions of dollars every year. No one accuses Harvard of being, well, some people accuse them of being greedy bastards, but, in order for them to keep operating, they should make some money every year. Okay. What if they gave some of that money back to teachers' salary so they could, it's not like Framingham has affordable housing somewhere if you look hard enough. I mean, some people can argue that, it's not desirable housing, but there is housing that can be gotten, and we try to build as much housing as we can. There's an affordable housing initiative for any new construction. So for me, it's a nice to have and not an absolute necessity. In the letter, they mentioned about the new H-1B $100,000 fee that would make recruiting harder. If you pay them a little bit more, maybe you can get them here. I mean, this is how IT the only people who and I'm going to go on a rant now about H-1B because I hated H-1B because I think it sort of depressed income for a lot of people in the United States. It's a nice to have. It's not a absolute necessity. I mean, New England Children's Center operated, over 55 years without this thing? Can they operate it without it? I think so. So I think you guys know where I'm headed with this.
Anything else on the board?
Okay, so I tend to agree with Christine and Lapp for the most part, but in addition, I'm confused why NECC isn't the owner of this property. Because if they were the owner of the property, then they could put classes there, they could do all kinds of stuff that would really make them Dover compliant. But they're not. They're leasing it from somebody who's leasing it from somebody. And it reminds me of a situation that we had on Route 30 with the Maris brothers, where they came into town and they wanted to build senior residence, and they got knocked down for that. And then they went ahead and said, oh, we'll make a hospital for, if I recall correctly, it was eating disorders. And they got knocked down for that, and they said, oh, wait a minute, if we hold some classes there, we can go into Dover. This kind of feels a little like that, where it's like, whoops, I think we have to go to Dover in order to get this done. Now, I don't have any facts to say that that's what you did.
I just want to, in case you don't remember, you probably don't, but I voted to say that was a Dover.
Oh, you did, huh? But they lost. And now we have.
I lost because I was the only one on the board. who
Right,
voted
there you
that
go.
way.
Congratulations. Okay, so for me, what doesn't feel right is the professional property developers who set up a shell corporation who find themselves like, oh, after they get NECC to buy in, then they had, it's weird, I guess it just doesn't, it's not like NECC said, all right, we'll buy this property. We'll buy the property, we'll have a section of it for classes, we'll have a section of it for dormitories. That would be okay, I think, but it isn't.
Anybody else before I go to the public? Okay. So what I'm going to do, we're going to go to the public, and again, new information. You've heard how we're feeling right now. And then I'm going to give each of the other sides 3 minutes to say what they want to say in conclusion. I'm going to time it. I'm going to put my timer on, and when the timer goes off, I'm going to find somebody to tackle you. Okay? But let's hear from the public, and I do, if he could jump up and down virtually, I think it looks like he was, because at one point, Phil had his hand raised and appeared twice with his hand raised. So Phil Ottaviani, Phil, go ahead.
Thank you, Chair Meltzer, for recognizing me. I'm zooming in also. We're on a family vacation, but I promised Mr. Bonanno I'd be here tonight. So I don't want to reiterate what I said at your first hearing. I don't know. Do you want my camera on? You can turn it on if you want.
It's up
I don't
to you.
mind.
Totally up to you.
You can turn it on. I'm on the deck. It's just we're on a family. My daughter thought she was going to spring break by herself with a friend.
Phil, you got muted. There you go.
There we go.
2 minutes. Give him 2 minutes.
We
So-
lost. Oh, there we go. Okay. Shh. Okay, go ahead.
I just want to reiterate, my statements from the last hearing. They're in the part of the record, so I'm not going to reiterate what I said, but I'm pleased to, I got to chuckle at it when you said you voted for it, because I voted against Walden back then. I remember those days when we were on the ZBA together, but I'm thrilled to hear what I'm hearing from the board, and I truly, and we are in a butter. We live at 630 Salem Road, and I'm speaking as an individual and not in my elected capacity in the city of Framingham, and I am not the counselor for this district, but I abut this district. I'm very happy with the comments that I've heard this evening, and I thank you people for doing the work that had to be done. So I look forward to hearing the outcome, and I want to thank you for what you folks do for the community, and I'm happy the neighbors rallied and put on the case that they did. So thank you very much.
Okay, thanks, Phil. All right, there's nobody else who's raised their hand in Zoom. Is there anybody here who wants to speak? Okay, so, Mr. Glick, you want your 3 minutes?
I don't think I'm going to take 3 minutes, mercifully. I think I'd only add a couple of things to where it sounds like the board is headed. And I think when Mr. Michel says it's totally irrelevant as to who owns the project property, and I think it's useful also for the board to consider that any kind of precedent that you might set. I mean, developers are not stupid. They're actually very clever people, and if you have if you set this precedent whereby a for-profit developer can come in, import a nonprofit, build a project, and then when you go back to something Mr. Michel said, well, at the end of this, we'll just have to tear it down. Well, I think the board knows that it would take a lot of guts to come in and say after 20 years that, no, you just have to tear your housing project down. So I think there's a precedent-setting value here that you should ponder. I think it works in our favor because I don't think you want to set this precedent. It's kind of like what Mr. Levy was saying. You open this door to this kind of contraption, if you will, this kind of Rube Goldberg gamesmanship, and you'll get more of it. So I would ask that you consider that. And I'd also mention that in terms of the Attorney General's survey of the law, I respect that. But, it's a general survey, and the devil is in the details, as I think the chair was pointing out, in all of these Dover cases. And the case law itself says that. For instance, the Attorney General cites the Tufts case and says, well, a parking lot is fine. Well, it was only fine because the Supreme Judicial Court found specifically that the parking lot was part of the core campus of Tufts. It didn't say that a parking lot remotely in Somerville or Cambridge was going to be okay. So there's a limit to what the Attorney General's opinion says. I'll shut up now and sit down, and thank you very much.
Thank you. So for the record, I know that it's in the record already, or in the record because Mr. Michel shared it as part of his submission, the Attorney General's guidance. But for the record, I shared that with the other board members before we even had the first hearing last month as background, so that they could have some information on the Dover amendment and how it worked. So it's not that it's being ignored. It did provide hopefully some background to some folks who might not have had any exposure to Dover before. So just wanted to get that into the record, Mr. Michel. You got your three?
So thank you for your time, and especially to Member Johnson, thank you for coming in on vacation to hear from us. Respectfully, I believe you are misreading Hume. Just very briefly, page 10 on the bottom, sub B. Hume contends that the primary dominant purpose of housing volunteers and seasonal staff at the RV camp would be to facilitate the operation, maintenance, and improvement of Hume NE, thereby supports Hume's religious mission. We agree. These are not campers. These are staffers. They are employees. That includes camp counselors, kitchen staff, and groundspeople that perform work that is necessary to the camp's operations. Teachers are necessary for the school. Therefore, it supports the educational mission of the school. It is Dover protected. Thank you for your consideration.
Well, he beat you there.
1 point for him.
Okay, so I guess I don't see any other hands raised. Anybody else? I think that's the last words. Back to us. What do you folks want to do?
I get a question. So are we voting to approve?
So it's an appeal of the building commissioner's decision to determine that this is protected by Dover. So we either vote to uphold his decision that it is Dover protected, or we vote, and we need a 3-0 vote if we want to overturn his decision to say that it is not a Dover protected use.
I will make a motion to overturn his decision.
Okay. There's a motion.
Second.
There's a motion and a second. Any further discussion? Seeing none? All in favor of the motion to overturn the decision of the building inspector, Christina?
Yes.
Lapp?
Yes.
And I am yes as well. So 3-0 to overturn. And as you could imagine, and everybody spoke of before, there's a good chance that this will be appealed, and somebody else will tell us how they feel about it. But thank you, everybody, for your participation. To the extent I was cranky, I think it worked. And I hope you keep coming back. You know, you're welcome here on any petition or application to express your feelings.
These are open sessions.
That's right.
So, Mr. Chairman, I am going to drop off the meeting since we do have some alternates that can step in. And any referrals for a divorce attorney might be helpful for me at this point.
Hey, Christina, thank you very much. I'm sorry you missed your dinner.
That's okay.
There are a couple of drinks in, but I'm sure you can catch up.
Cabin service, use the cabin.
We're gonna take 3 minutes while everybody clears out and get a breath. So we're not in session.
The Government Channel's core mission is to make the Framingham City government accessible to everyone. Social media tools, like our Facebook streams available at Framingham TV, help the city build engagement and connect our audience with our content and services. No matter where you are, you can always participate in the decisions shaping our Framingham community. Also, Government Channel broadcasts feature state-of-the-art closed captioning, providing a critical link to news and information. Whether you're in the comfort of your home, on the go, or need accessibility services, the Government Channel provides everything you need to help make decisions and understand Framingham's governmental organization. We help everyone to participate effectively in our city's democracy. The Government Channel, telling Framingham's story.
We're going to do the new hearings. First one is 2602 20 Hardy Street, Jamal Siddiqui. Let me grab the file. We're going to read this into the record and get this going. And I understand the applicant is attending by Zoom.
Mr. Chair, I'm a direct abutter. I'm not sure if I should recuse
You
myself.
probably should, yes.
Unless you feel you can.
No, a direct abutter, probably not. So on this will be myself, Mr. Yan, Mr. Levy, and let's do, who should we do? So I don't remember who was last, but let's do Francis as the alternate, since he recused himself last time. All right, so notice is hereby given the Zoning Board of Appeals will hold a public hearing on Wednesday, March 11th, 2026, in the Bloomer Community Room of the Memorial Building, lower level, 150 Concord Street, Framingham, and/or via remote conference to consider 2602 at 7 p.m. petition of Jamal Siddiqui for any necessary approvals, findings, special permits, and/or variances as may be required by the Framingham zoning ordinance in order to allow the proposed vertical extension of lawful pre-existing non-conforming residential accessory structure for the purpose of constructing an addition to a detached garage for use as an allowed accessory dwelling unit pursuant to 435-4D2 regarding premises located at 20 Hardy Street, parcel ID 071287094, zoning district, single-family residence 1. Mr. Siddiqui or whoever is here on behalf of the applicant. Are they here somewhere? I see somebody with their hand. Okay, there's, yeah.
Took too long.
Give them a minute to sign back on. There was somebody with a hand raised, but now they're gone. Yusra?
Yes.
Okay, Yusra.
Yep. So Yusra Design Build is my company.
Okay.
So we are a design build company, and I'm the owner, Jamal Siddiqui, and I also am the primary owner of 20 Hardy Street as my primary residence.
All right, so you wear many hats here.
Yes, sir.
Okay, so why don't you describe for us what you're doing and why you think we should vote to give you a finding today?
Sure. So we recently moved into 20 Hardy Street, purchased the home, and have been extensively renovating the main house. And while doing so, we are hoping to also take advantage of the accommodations set forth by Massachusetts to allow for an ADU. And the main reasoning for this is because I do have grown parents, aging parents that live by themselves, and both have been having surgeries and so on and so forth. And this would be an ideal situation for them to have their own space while my immediate family, wife and kids, having their space as well. So we've given a lot of thought to doing a vertical addition to the detached two-car garage and asking to do a 300 square foot studio style ADU, which should not only sit towards the back of the garage, mainly because we want to make sure that there's visible privacy, and it's not so much so that the addition is sitting right on top of the main residence, because they are both flat roof, mid-century style structures, and it would look overbearing if it sat towards the front of the garage. So we kept it towards the rear side of the garage, mainly so that there's privacy both ways. And also paid respect to make sure that neighbors don't have any windows facing their side, so that they can maintain their privacy as well. We only have a few windows facing Emily Road, and a couple of windows facing the backyard of our house, and a bifolding door and a couple of windows facing towards the main residence, but it's set far back enough that you wouldn't have a direct view down into the house.
Okay, so a couple quick questions. You are staying within the current footprint of the building?
That is correct.
And you're not increasing the nonconformity other than making an alteration of something that's already nonconforming because of the setback, is that right?
That is correct. And even though the setback, just for clarity purposes, the setback of the garage, it's ironically only the rear left-hand corner of the garage that is encroaching the setback. The rest of the garage is within the required setbacks.
Right, it's usually only one piece of that does. Okay, that's all I have. Any other questions from the board?
Yeah, a quick question. Are you planning on renting out the property, or is it for a family member?
Currently, I'm just thinking about using it for immediate family. There's no intention of renting it out.
Okay, thank you.
Anybody in the public wishes to speak on this? I don't see anybody other than Yusra who has his hand raised. Okay, back to the board. You guys, what do you want to do?
I'll make a motion to approve as submitted.
Okay.
I will second it.
Motion and a second. Is there any further discussion? Seeing none, all those in favor?
Aye.
Aye.
Aye. 3-0, you got it.
Awesome, thank you so much.
You almost fit within that 3 minutes.
Salem
Yeah, that was
Road beat
interesting.
us into
That
the
was definitely
ground.
interesting.
Salem Road beat us into the ground, but we'll take anything now.
All right, you guys have a wonderful night.
Thank you, you too.
Thank you.
Okay, we're going to move on to 1143 Grove Street. Let me open this up, read it into the record, and then we'll get started. On this case will be myself, Mr. Yan.
You've one of the new guys.
Yep, it's going to Mr. Parker because he had to recuse himself last time, not that it mattered too much. And,
We get some sign.
huh?
No, we haven't gotten a sign.
We're
out.
getting some signs, right? Do we have signs in April, right? One sign in April?
Yeah, you're
There you
involved
go.
in the signs.
And McCarthy
Associate
is the
members.
alternate.
Associate members. Signs are a big thing.
Okay, notice is hereby given that the Zoning Board of Appeals will hold a public hearing on Wednesday, March 11th, 2026, in the Bloomer Community Room of the Memorial Building, lower level, 150 Concord Street, Framingham, and/or via remote conference to consider 2603, 7 p.m. petition of Richard and Dr. Donna Tizard for any necessary approvals, findings, and/or special permits and/or variances as may be required by the Framingham zoning ordinance to allow the construction of an accessory structure, shed, proposed within the side setback pursuant to 43527B regarding premises located at 1143 Grove Street, parcel ID 02467. 676064, zoning district, single-family residence R4. Sir, why don't you introduce yourself and tell us what you're hoping to accomplish and how?
Sure. Yeah, I'm Richard Tizard, and this is Donna Tizard. We're the two owners and residents at the property. And what we intended to do back in November was to upgrade our shed. And our shed was an 8x12 structure to the side of our house, in the back a little bit, up against the pavement, so we could, get to it. But it's getting too small. It was not new 15 years ago when we moved in. And we wanted something larger. And we also thought while we were at it, we'd make something more attractive. But it turns out when we decided to do that and center a twice as large structure, a full 200 square feet instead of 100, and the same location, our permit was denied. And the original shed, it turns out, in the corner, as you said, there's only one part that necessarily has to infringe, right? The right rear corner was already within 22 feet of the property line. And so what we intended to do was to go to 18 feet. So we have something that starts 18 feet from the property line and projects 16 feet towards our house, centered on where the old one was. And we have some, what I think is the most useful, Jackie, is the less formal diagram that actually it's got some blue on it, and it shows the abutters, which this doesn't show. We did have, a formal survey done. Yes, it looks just like that.
She got it.
And she's got it now, right? So you can see the little structure in brown, red around it. This is the new size of it, right? And it does, in fact, come to within 18 feet of the property line. Now, the closest building to that shed to the left is what I refer to as the north barn next door. It was used for many, many years as a horse property, and that was where they actually kept the horses. If you actually zoom out just a little bit, that's about 90 feet away. This one at the bottom is the south barn. That's a huge structure. I provide you with a picture of that. Much, much, much larger, and it actually, since there's an upslope, it starts above the grade level of our shed. So once we found that we were, denied this permit, it became important to talk to all of the abutters, and this butter in particular. His name is Justin Moore. He actually grew up in this house. He's a grown-up now, and his parents, Dr. David Moore and Jay Moore, have moved to Maine, the last I heard. But this is his childhood home, and he's very comfortable with us having a somewhat larger shed in that same utility area shared with his two barns. Another thing you can see is that, the abutters, his house is quite far. We have a long, thin parcel. So does he. His parents chose to put these accessory structures in the back of their property, which is kind of where our house is, because we're way off the street. We're 100 yards off Grove Street. What was I going to say? The other abutters, so they're 200 feet away, their house, and there's the north barn is partially blocking their view of this. That is not a concern for him at all. He doesn't care. The other abutters are also pretty far away, and two of the three abutters are pretty far away. They're sort of up near Grove Street as Justin is, 200 feet away, and are very supportive of this project. They think it would be an upgrade, to the environment, and they're happy with it. The only abutter that's a little bit closer is completely blocked by the house. Our house is between our shed and his house. And they have no concerns either. And they have a very similar shed to the one that we're planning on putting in. So
So you're going 4 feet closer to the lot line with a little bit bigger shed. Now,
Yes, sir.
Jackie, they're already non-conforming. Why, we could have done this as a finding, I think. It's pre-existing non-conforming structure. It's an increase of a pre-existing non-conforming structure. We would just need to enter a finding that it's not substantially more detrimental.
Right.
But-
I am
but the-
knocking down the old shed. Is that understood?
Yes, that's
Okay,
understood.
okay.
Yeah, but I mean, I don't have any problem giving a variance because I would give a finding in this. And that's, I think, all they would need.
Yeah, I mean, I gotta ask the question, why can't you just move it over a little bit so that you don't increase the nonconformity? Because then,
Well, you would have to move it over 8 plus 4, 12 feet.
Yeah, that's the same question I had, because it seems like their parcel is relatively flat, and I don't see why they couldn't maintain that setback and get closer to the house. I don't see any
Well, have
obstacles in the way.
taken a look at this picture?
Yeah, I have.
yeah.
Yeah, it seems
if
like
we-
there's
if we
plenty of
push-
space. It just seems like you have like a small, maybe 3-4 inch diameter tree, approximately like 20 feet to the left of the existing.
It's bigger than 3 or 4 inches. It's at least 20 years old.
But
But it's not a huge tree, I will agree with that.
But is there a reason why you can't keep the same nonconformance? I understand that there's a preference for you to put it there, which really isn't a case for us to grant either a finding or a special permit or a variance. You know, it's, if you just move it over X amount of feet, it would just be a no-brainer for us.
Move it over 4 feet.
Yeah, I mean, if they are increasing the nonconformance, that's my headache with it.
Well,
We
it's-
write zoning laws for a reason.
I guess it just makes more sense for it to be sort of where the
Sounds familiar,
existing
Ryan?
one is in terms of being on the edge of the driveway rather than sort of more splat in the middle of it. You know, it's just sort of more out of the way.
I mean, again, that comes to a preference, not a necessity. Again, going back to the old case, is it a nice to have or is it a need?
Yeah, I understand the question. So my answer would be two-pronged. I mean, there's no point in my mind, nor in our abutters' minds, that we want to, keep it farther from these barn structures. Their homes are a long ways away. It's an unusual property, I think, in many ways. And so I think that if what you're trying to do is you're trying to protect, the neighbors and the neighborhood.
Well, we're trying, I think more in this case, we're trying to protect the integrity of the bylaw itself, which says that 30 feet is the setback. You're already at 22. There's no hardship in staying at the 22. It just may, I mean, as I look at this photo that you provided, if you go over 4 feet, you're lined up with your poles now on the left side. 4 feet is
Well,
not.
we don't love that, so it,
Well, but we
there's
don't
an
love that
aesthetic
isn't
issue
the
here.
reason to grant zoning relief, I guess is lapse point, right?
That is my point, it's a nice to have. Is it an absolute positively need?
Well, I wouldn't move this shed over 4 feet. Aesthetically, I just don't like the idea. Maybe we could come to some sort of an understanding where, so you're happy if we leave it at 22 feet? Do I understand that?
Absolutely.
So if it starts at 22 feet and comes less far, maybe we only go, 14 feet instead of 16, or we do something like that.
I mean, I just don't see the need to increase the nonconformity with this, just looking at the site, to tell you the truth.
Well, yeah, I don't want to invite you to come to the house. I mean, you don't have the time for that. I mean, I've seen how your lives, how you spend your lives.
We've gone to other people's.
If you want us to, we will.
Yeah.
If you think we're gonna
Well,
see something that we don't see in the pictures.
Well, I think it's, a homeowner's perspective on the aesthetics versus someone else's.
Yeah.
And I'm not sure I could convince you.
It's not a matter.
I'm not sure I could convince you, right?
I'm not sure you
It's not a
could.
matter of aesthetics
So-
for me. It's a matter of following the bylaws. I mean, we.
Well, we're trying to,
trust-
it's the purpose of the bylaws, though, right? I mean,
No.
okay.
I don't know. I mean.
I mean, the next door neighbor has been, they've owned this property for a gazillion years. They operated as a horse farm. To have this over 4 feet closer to this once and future horse farm, to me, I don't get it. But if you want us to try to come up with a 22-foot solution, how would we do that? Would you say anything that starts at 22 feet is okay with you, and I could just go ahead and start over with the planning of it? Because, maybe I'd go to something that's more square, or something, right? Do you
Well,
understand?
I mean,
Do
so that you
understand?
don't have to come back, I would say that we could say that,
I mean, right now, you have, it's 22 feet. If you have any structure that's 22 feet away from that setback, we can make I would grant you a variance based on the 22 feet.
it shouldn't need one because it's a.
It's a pre-existing condition.
Pre-existing, but I don't want to get it caught up in the building department.
Yeah, absolutely. I mean, we can grant them that.
This is 16, what you're proposing here is 16 by 14?
No. What are we?
I think it's
So we have 8 by 12, 16 by 12.
By 12.
16 by 12.
It's 12 deep, we're going to leave it 12 deep and make it wider.
So I would say that in my mind, so that's 192 square feet, that if you do anything that's 200 square feet or less, that we are allowing you to do that at the 22 feet, right? Does that make sense?
Not to exceed,
Yeah.
not to exceed the current.
Right.
This shed is not on a concrete foundation, it's on a bed of gravel, right?
Right, and that's the
It's-
plan for the new one as well.
So whatever configuration you do, as long as you don't exceed 200 square feet, then, and don't go any closer than 22 feet to the lot line, then we can live with that. And
What about 21 feet? One of the reasons I ask, no, I'm sorry.
I like it.
Mr. Yan, I'm
Sounds
sorry.
familiar.
It's because if we do go back a couple of feet
Yeah.
to try to get, well,
If you make it longer than wide, then you're going to end up
just
1
adding a
foot
couple of
closer
feet
in
might
the
get us to
back.
21 feet. So if it starts at the same place, you know what I mean? It's complex.
Corner, so if you start the corner at the same place, you might end up 1 foot closer at the back furthest point.
Exactly.
That sounds like an architectural issue.
I mean, short of get.
Yeah, I feel like, I personally feel like there's plenty of space.
I think
We're
there's-
arguing, because we could require to step back like 30 feet. Because imagine if I lived in a neighborhood and I went to all my abutters that I've known for years, and I'm like, hey, can I put my shed closer to your property? And he was like, yeah, that's fine. Then the zoning bylaw wouldn't really matter at that point, if everyone made like a
Right,
gentleman's
but
agreement.
are your neighbors 200 feet away?
Well, but wait a second, you're actually 18
doesn't-
feet currently.
No, that's the proposed.
No,
Oh, that's a proposed.
currently
The
it's
back corner's
22
18
feet.
Yeah,
So I am
okay.
an architect, I can read drawings.
Yeah.
And I'm gonna use my lived experience, okay? I, as a person who had to move his shed because I thought I could cheat a little bit, because I wanted a little bit, but once I got the violation, I moved it. So I really, I like you guys, and I think you want to do the right thing by your standards in your house, but as someone who had to spend $1,000 and to move his shed, I really have no sympathy, to tell you the truth. And I complied with the bylaws.
So, I mean, I'll leave it up to you if you want us to come take a look, and you can try and make your case, or we can give you your
Again,
22 feet.
I think it's all about the aesthetics.
I hear
As
ya.
we try to make it better, we want to make it better in a way that pleases us.
Yes.
And there's no reason why you would necessarily have to agree. So, I think the pictures and everything sort of told the story, so I think we're there.
All right.
But you're welcome to come by anytime.
I think we still have to grant them a variance for the 22 feet.
Yeah, I think we should, just to make sure that the building department doesn't
Hold up the building permit.
Yeah. So, is there a motion?
I'll make a motion to grant them a variance at 22 feet off the side yard setback.
For 16 by,
I really don't care what size shed
Let's
they
say
put
200
on.
square feet.
yeah,
I
200
really don't
square
care,
foot.
as long as they're just 22 feet away from that side yard setback. I have,
So that-
they can put a 50,000 square foot shed on there for all I
No.
care.
For two, because they are within the setback, so
Yeah.
22 foot, a variance for 22 foot setback for a shed that is 200 square feet or less. Is that the motion?
That's the motion, yes.
Okay, is there a second?
Second?
Okay. Any further discussion? All in favor?
Aye.
Oh, am I voting?
I think, aren't you on this?
Yeah, I am, but
Can I put you on this?
I didn't think an alternate vote.
Because he
Yeah,
had,
put you on this.
he
You're
recused
voting.
himself.
Approved.
Okay, and I'm a yes. So
Yeah, so we,
you didn't get what you wanted, but still move forward.
So are you going to explain to me what the next step is, or do we just go ahead? Is there
I'll
paperwork?
send you an email. I'll send you an email tomorrow.
Thanks, Jackie.
The short explanation is Jackie will write up the decision, I'll sign it, we'll get that done within 2 weeks.
You can file for your
It gets
building
filed at the town clerk, city clerk's office. Technically, you're supposed to wait 20 days for an appeal period. If nobody appeals, then you can take that, record it, and bring it to the building department and get your building permit to get it done.
What does the word technically mean in that context?
Means if you go ahead, you do so at your peril because somebody could appeal, but who's going to appeal?
Right, okay.
It's at your own risk.
Well, that was an easy one, right?
Yes, and sorry you had to wait through
Oh, yeah.
the entire
Well, it was
process.
instructional.
You should have put him ahead,
It was
I
instructional.
wanted to keep Christina happy. She almost had to ditch on us before we got to it.
Well, fill her in on the details of our shed when you get a chance.
Okay,
Thanks a lot.
thank you.
Thank you. Good luck.
Okay, it's not as late as it could be.
No, you know what? I was expecting 10. We gotta start the pool of when we can end again, you know?
The over
Remember
under?
that? The old, we used to have a pool of what time it ended, and I forget what was the prize.
Forever.
Ron, when we was here, I was betting 10 o'clock all the time.
I wonder if they teach verbosity at law school.
Okay, so we're still on the record unless somebody wants to make a motion.
Oh, yeah, make a motion to adjourn.
For a second?
I'll second.
Motion a second. Any further discussion? All in favor?
Aye.
Okay, we are adjourned.